So the ATF has now filed a petition up to the Supreme Court and is asking for the Supreme Court to review and protect their bump stock ban. So let's talk about this. But real quick before we jump into this video, I want to thank one of the main supporters of this channel, which is USCCA. Through your membership, you get training, education, and self-defense liability protection. I have USCCA. I actually had their membership before I ever became a partner with them, and it's a good idea to have some sort of legal protection if you carry concealed or if you just have a firearm for self-defense, because you have to worry about what's going to happen if you ever have to defend your life or someone else's. So I highly recommend USCCA. You can check them out using the link down below or in the pinned comment. And thank you again to USCCA for sponsoring this video. As I mentioned in the intro, in this video, we're going to be discussing some news about the ATF now filing a petition up to the Supreme Court and asking for the Supreme Court to review the bump stock lawsuit. That case that we're going to be talking about is called Cargill v. Garland, and it's a challenge to the ATF's new final rule on bump stocks, which essentially banned bump stocks and claimed that they were in fact so-called machine guns. This decision by the Fifth Circuit en banc panel struck a major blow to the ATF's current overreach and their claimed authority to regulate these types of items. In this important decision, the Fifth Circuit en banc panel found that the definition of a machine gun, as outlined in the NFA and the GCA, does not apply to bump stocks as an item. And now the ATF has been forced to file a petition up to the Supreme Court to review that Fifth Circuit en banc panel decision. And really, either way, there are some huge silver linings and some really good potential that could come out of this case. One of the important aspects of this challenge was whether Chevron deference should be given to the ATF in relation to their final rule on bump stocks, or whether a different rule, called the rule of lenity, would in fact direct courts to rule in a way that is more favorable to us the people instead of the ATF. So the concept is that when a statute has ambiguous terms, the agency responsible for enforcing that statute, like the ATF, may be able to determine what that term was intended to mean as long as their interpretation of that term, of that statute, is rational or reasonable. In contrast to Chevron deference, there is a different rule called the rule of lenity. And the rule of lenity indicates that when dealing with criminal statutory interpretation, a court is required to apply any unclear or ambiguous laws or terms in a way that is most favorable to people, not an enforcement agency like the ATF. And that is because there are criminal implications that are involved with certain statutes, for example, like the NFA and GCA. Well, in a 13-3 decision, the en banc panel in the Fifth Circuit ultimately found that the ATF overstepped their authority in regulating bump stocks as so-called machine guns under the GCA. In fact, the court stated that a plain reading of the statutory language paired with close consideration of the mechanics of a semi-automatic firearm reveals that a bump stock is excluded from the technical definition of machine gun set forth in the Gun Control Act and the National Firearms Act. The Fifth Circuit went on to say that nor can we say that the statutory definition unambiguously supports the government's interpretation. As noted above, we conclude that it unambiguously does not. But even if we are wrong, the statute is at least ambiguous in this regard. And if the statute is ambiguous, Congress must cure that ambiguity, not the federal courts. In this decision, the en banc panel clearly identified that the definition of a machine gun in the GCA and the NFA does not include items like bump stocks. And even if the term were considered to be ambiguous or vague on that very issue, the court concluded here that the rule of lenity would direct an interpretation in favor of us the people, not the ATF. If Congress or the ATF wants that definition to include these types of items, then the burden is on Congress to change the statute. But the ATF does not get to do that on their own. They do not have the power to be the judge, jury, and executioner. Now, after that decision, there was discussion going around and pointing to the fact that Monday, February 27th, was the last day for the ATF to file a writ of certiorari up to the Supreme Court to challenge that decision by the Fifth Circuit en banc panel. The claim was that the ATF did not do that they did not file by that deadline, and therefore the Fifth Circuit issued a mandate back down to the district court. The whole concept going around, the discussion going around, was that the ATF conceded the case and was not going to seek Supreme Court review. Again, some were claiming that. They were claiming that bump stocks were now legal. Even there were some shops alleging and claiming that they would start to sell these items. However, I went on the record in prior videos before and after that mandate telling everyone that the ATF did in fact have until April to seek Supreme Court review. I even called multiple attorneys who work in the Second Amendment litigation sphere. They work for large two-way national groups. I had discussions with them, said, am I getting this wrong? I'm looking at the federal rules. It says that the ATF has 90 days. That would be April. They can still file for Supreme Court review. And we all came to the same conclusion that yes, the ATF could still file for Supreme Court review. Now, again, people were saying that that wasn't going to happen, that the ATF already missed that deadline. But lo and behold, here we are. The ATF did in fact file for Supreme Court review. Also, I saw some videos and articles claiming that since the mandate was issued by the Fifth Circuit, that bump stocks are now legal to sell in states like that are covered in the Fifth Circuit. Now, here I want to be clear, this is not legal advice, but my opinion is that just because the mandate was issued by the Fifth Circuit back down to the district court, that does not mean that the district court has issued their final relief. The Fifth Circuit issued their mandate, but it states, having determined that the judgment of the district court must be reversed, we remand this case to the district court to enter judgment for Cargill and to determine the proper scope of relief. It goes on to state that the parties have not briefed the remedial scope question, and it may be the case that a more limited remedy is appropriate in these circumstances. We express no opinion on that question, other than to observe that the district court is well placed to answer the question in the first instance. So what does this mean? Well, this means that the Fifth Circuit did remand the case back down to the district court to decide on what type of relief should be granted. The district court has not yet actually determined that relief, and the ATF this week in fact requested a stay on the briefing of what type of relief or what scope of relief should be granted. And in that request for the stay of that whole procedure, the ATF indicated that they would file cert up to the Supreme Court, and they would do that before April 6th. And sure enough, on April 6th, the ATF filed for Supreme Court review. That means that the ATF is now asking for the Supreme Court to reverse the findings of the Fifth Circuit en banc panel, which found that first, bump stocks are not machine guns under the plain text of the statute. Also, the ATF is asking for the court to find that the ATF does in fact have authority to engage in these types of rulemaking processes and to engage in this type of interpretation process. Now, of course, this has huge implications for other types of ATF actions. If the Supreme Court takes up this case, this decision will have huge trickle-down impacts on other ATF rules, like their rules on frames and receivers and their new rule on pistol braces. So this still has a ton of steps to go through. However, I think the ATF has now essentially been forced to have to gamble, roll the dice, and seek Supreme Court review, and they're going to have to litigate this before the Supreme Court, who just last year issued a 6-3 opinion in the New York State Rifle and Pistol Association versus Bruin decision, which struck down the state of New York's concealed carry law. So it's definitely not a court that's leaning in their favor, but the fact that the Fifth Circuit en banc panel struck down the ATF's bump stock rule and that whole regulation is now forcing the ATF's hand. So that's where the bump stock case currently stands. If we get any more information, of course, I'll let you all know. Also, if you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of two-way news. As always, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.